I'm Suzanne and I'm a barrister at Searle Court Chambers, and I specialise in competition law. I'm here to discuss a monumental decision of the UK Supreme Court. The Supreme Court has dismissed an appeal by Mastercard against a decision of the Court of Appeal. The Court of Appeal had found that the Competition Appeal Tribunal, or CAT, was wrong to refuse to certify an application for a collective proceedings order, or CPO, in a case bringing a claim for competition law damages against Mastercard. The case arises out of the European Commission's interchange fee investigation, which found that Mastercard's multilateral interchange scheme fees infringed EU competition law. As part of this, merchants were found to have passed on the inflated fees direct to consumers. Back in July 2017, the Competition Appeal Tribunal had refused to certify the application for collective proceedings. And one of the main reasons for doing so was that the approach in Merrick's calculation didn't make it possible to precisely quantify the loss that had been suffered by individual consumers. The Supreme Court found that the CAT was wrong in its approach to certification, and one of the main reasons was that the CAT had failed to take sufficient account of that long-established principle under English law that the claim should be allowed to proceed if the claimant can show that they have suffered some loss, and it wasn't necessary to precisely quantify that loss at the outset. Second, it's significant that collective proceedings are a special type of damages action. They'd been created by the legislature precisely to address some of the difficulties with individual claims. And it would produce a blunderbuss of that to certify on the basis of the same tests for individual cases. So one can see a very strong policy driver behind this decision. On the question of suitability, the CAT should have first considered whether the case was appropriate or suitable to bring by way of collective proceedings. It was then necessary to consider, of course, whether an award of aggregate damages would be appropriate. But this latter consideration was not an absolute barrier to bringing collective proceedings. On the question of aggregate damages, it's well to keep in mind that a central purpose of this power to award aggregate damages is inherent in the nature of collective proceedings. The CAT had found that the case just wasn't suitable to proceed on the basis that an award of aggregate damages could not reverse engineer and identify the claims and losses of individual claimants. Now, the Supreme Court has made it clear that this is plainly not a hurdle, although it is a relevant factor for the tribunal to consider, but this is not a condition at the certification stage. The CAT also failed to appreciate the extent of common issues in this case, and certainly the question of the amount of Mastercard's fees that were passed on to individual consumers was a common issue to the relevant class. The breadth of these common issues was certainly a factor that the Supreme Court said should weigh heavily in favour of certification in this case. So what are the implications of this decision? Well, for immediate purposes, the focus now will be back in the Competition Appeal Tribunal. The case has certainly not been given a green light, but the CAT will now need to consider whether the case is suitable to proceed by way of collective proceedings in light of the guidelines and judgment of the Supreme Court. So the focus will be very much around this case and whether up to 46 million consumers may be able to claim on this basis. It certainly represents a lowering of the bar relative to the test that the CAT had originally outlined. And there are a number of other cases that are waiting in the wings. One arises out of the European Commission's Forex decision. There's another claim for damages which concerns a claim against 3 UK train operators. This is an abuse of dominance case. So certainly the principles outlined for collective proceedings should be transferable to cases that relate to infringement under Article 101 or Article 102 and the national equivalents. Looking forward to the merits, as I've emphasised, the merits case has not yet been given a green light, and a decision, if the CPO is approved, could be some years down the line. Nevertheless, the Supreme Court's decision has emboldened the claimants in that case, and in my view, will be a spur to others considering bringing collective claims. Mastercard and Merrick's fight another day, but certainly this decision has injected a newfound optimism amongst claimants.